The Department of Justice saying in a new court filing that it may recommend breaking up Google's search business. For more on what to expect, we are joined by Harry First. He's a professor of law at New York University, also part of New York State's Department of Justice. During the Microsoft?
Some years ago, yes.
Okay, some years ago.
We pretend Microsoft was just yesterday, but it wasn't. Yeah.
Just during the early 2000s. Right. So a fantastic guest to have on this because you were there really at the forefront of the last big regulatory push against big tech, which was with Microsoft. What similarities do you see today with Google?
Actually, the plaintiffs in the case, and we have to remember it is the Justice Department and many states. Mm-hmm. So it's not just the Department of Justice, but the plaintiffs have actually based their case around the law in Microsoft and have brought this case as a maintenance of monopoly case, just like they did in Microsoft, an effort by the dominant firm to maintain its position by engaging in various kinds of exclusionary behavior to keep out the competitors. So.
Do you think, bottom line, correct me if I'm wrong, but the agencies can't order a breakup. So what is the likelihood, in your opinion, that a judge really, at the end of the day here, is going to order a breakup of Google? What odds would you actually give that?
So are we doing betting markets now?
Yes, absolutely.
Yes. So I think the odds are, is medium a word for the odds?
Sure.
The odds are medium. So there are several hurdles. First is the district court judge who tried the case himself. Very careful judge, Judge Mehta, very thoughtful judge. He may consider a breakup, but first, the government plaintiffs have to actually ask for one, and it's not clear from their current filing, which is just a remedies framework. We're not going to tell you what we're asking for. So it's not clear they're going to ask for it or how. So first they've got to ask. Second, the judge has to agree. Judges tend to be conservative, and they're not looking to make tremendous waves.
That would be a big wave.
Yes, yeah. They don't view themselves as industrial organization economists. They're judges. So the judge will be cautious, as the judge in a related case that Epic has brought against Google was careful. And he said he doesn't want to be too interventionist. So that's the first hurdle. But the law would allow the judge, if the judge can support the decision, to impose whatever remedies are necessary to unfetter the market, is the language, to restore competition. So that's the first hurdle. But then the second hurdle is the judge has to convince a court of appeals to do that. And the other parallel to Microsoft is that in the Microsoft case initially, the judge had ordered a breakup of Microsoft, stayed the remedy. And for a number of different reasons, the Court of Appeals threw that remedy out, but also indicated that it was not anxious to do this. You really had to have a lot of support, a lot of causation connection between what the defendant did and the maintenance of monopoly, and that this would be a remedy, the language was tailored to fit the wrong. So courts of appeals, the Court of Appeals, particularly in the DC Circuit where the case was tried, have been sort of conservative towards remedies. The remedy that was ultimately chosen in Microsoft was done by agreement, by negotiation. This one so far is not. So that's another aspect to how a Court of Appeals might look at the case.